Hello, everybody. We are live on Facebook Live, streaming through StreamYard. My name is Rick Hein, and I am a lawyer in St. Louis, Missouri. To my left is Alexandra Johnson. Alexandra, please introduce yourself.
Hi, my name is Alex Johnson, attorney at law, and I focus on estate planning.
Great. So today we are doing our first joint live event through Facebook, and we decided to sort of team up, and we're going to be doing this right now in English, and then in 1 hour we will go through the same format but in Spanish. So if you're a Spanish speaker, please tune in about an hour, and we will be back here live with Alexandra and me. And so today's topic again is the top 10 tips and questions about estate planning. And Alex's main focus in her practice is estate planning. So I think she'll be pulling the laboring oar during the questions. But what do you say we go ahead and just get right into the questions? And people in the public, if you're watching, you can, of course, post questions and we'll try to answer those in real time for you. How does that sound, Alex?
That sounds great.
All right. So our first question is, what is the difference between a will and a trust?
Well, so pretty simply, if you die without a will, Missouri has laws that take care of your property, dispose of everything you own. However, you can also make a will, and that's when people think of estate planning, that's usually the first document they think of. A will is a pretty short document. It's often 5 to 6 pages. There's only so much that you can do with a will, and it does have to be probated. You have a year to probate it, to file it in probate court. That is not a DIY area of the law. You do have to have an attorney assisting you with that process. A trust, on the other hand, can also be a short document, but tends to be quite a bit longer, can be quite long, 80, 100, 200 pages, depending on exactly what the complexity of the estate plan is and the needs that need to be addressed in the document. It's common thought, it's a little bit of a myth that if you have a trust, you don't need probate at all. That isn't necessarily true depending on the circumstances, but one of the primary benefits of a trust is that anything that is in the trust will usually avoid probate. So you don't have to go to probate court. You don't have to file anything. If, for example, your home is in trust or a bank account is in trust, your trustee, who does not need to be a lawyer, can then take that asset, take control of the asset, and distribute it. Of course, there's a process. You don't want to just do that willy-nilly. It does not mean that the trustee, even if the trustee is a beneficiary, can just go in and dip into those accounts. It can't be done willy-nilly, but it does avoid probate court, usually for the assets that are held in trust. So that's kind of the big difference. Lawyer with probate, and it can be a non-lawyer. It can also be a lawyer, of course, but without probate. So probate, not probate. Those are the biggest differences.
Probate versus non-probate. Okay. I think that was a really good answer. Looks like we have another question, and we'll go ahead and hit that one. What happens if I die without a will?
Right.
So in American jurisprudence and law, we call that intestacy, or dying intestate. That's a fancy word for saying I didn't have a will when I died. So what happens if that happens? What if I die without a will?
Right. So I started to talk a little bit about that, but I'm glad we're coming back to it. And that is, Missouri, as do all 50 states, have a way to take care of your property if you die. So if you pass away and don't have something in place, there is a process to take care of whatever you own. And those intestacy laws have rules. They do vary a little bit from state to state, but generally speaking, next of kin is going to get it. So if you own a property of any kind and have to have a house, for example, and you have a wife, it's going to go to that individual. If you have a wife and children, it will be split in a certain way. And that's just all designated because a lot of people ultimately don't do any estate planning.
Right. And so I would say that if you decide not to have a will, it's probably a decision that, well, everybody can make that decision. Some people just don't make a decision, and then by default they end up without a will. And then it's not you, the individual, deciding where your stuff goes after you die, but rather the legislature of the state in which you live and die. So it may end up where you have assets going to people that maybe, if you had thought about it and taken the initiative to prepare a will, would end up with assets that maybe you didn't want them to have, or people end up with being excluded, by default because you didn't take the action in advance.
That's a huge issue, Rick, and I'm really glad you brought it up because you can have a situation, for example, where maybe you're not formally divorced, maybe you've just separated. A lot of times, couples, I've worked with couples who got separated years ago. I've worked with people who were separated for 15 or 17 years, and then one of the individuals died, and they were technically still married. So that can definitely be a matter of concern. It's also a big area of concern when you have children, minors, that you're taking care of and love, and you want them to receive something, but they're not technically in your will. Maybe you don't want to marry the mom. Maybe you don't want to marry the dad. Maybe that's not it, but you have a relationship with the kids. And unfortunately, without something in paper, so that can definitely, they're not going to get anything if you haven't specified it. It will be by blood relationship, by next of kin rules that property transfers. So it's a very good issue. The other thing that comes up really that's huge for people who die without a will in place is that when you put a will in place, which you do normally or frequently is what I recommend to my clients, is that you say that they don't have, you waive the bond requirement. Otherwise, your loved ones are going to have to post a bond. And one of the situations that we have a lot of times with maybe, not wealthy individuals, but not all of us are wealthy. And maybe we have a sister or a brother, a wife or an uncle who's going to take care of the property and would actually step in and distribute everything, but they would have to post bond because the court needs to know that they're not going to abscond, they're not going to sell the house and take the money and go to the Grand Caymans or something like that. So they're going to have to post bond, but you can waive that. And a last situation that comes in is you may have somebody like your sister is maybe doesn't speak very well, doesn't come in, maybe arrives late all the time, but she's the one that you trust with your stuff and trust with your kids, for example. And that's where how you want to designate things, because in the will is where you'll also place the guardianship for your children. Yeah. Then you might have an uncle or another sister, a different sister, with whom you actually didn't get along that well. You don't want her to have your kids. You don't want her to take care of your stuff, but she's the one that shows up in court. So what's the judge supposed to do? Like when they are assigning this duty and designating a personal representative to take care of the estate, they are not going to know all of the family relationships and the history that may or may not be relevant. If they did know all the ins and outs, they might factor those in. But people present in court differently, and that doesn't mean that if they may arrive late for a formal proceeding or may not handle the paperwork that well, but they may be exactly who you want to take care of your kids because that's what you want and think is best for them. But if you don't have that designated, that can create a real problem with minors as well.
Yeah. So excellent. All right. The next question we have is, what is probate? So let me just take a sort of a bird's eye view of that. Probate is the place you don't want to end up as a dead person. Or rather, I suppose it should be stated that it's not where you want to send your loved ones after you die, because it adds delay and cost to the disbursement of your assets. So I guess the best answer that I would give is probate is, well, the legal reason that people have to go to probate is because their wills have to be proven and then assets distributed through the court. But really, that's something that with the help of a good attorney, you can try to avoid. You can avoid the delay and the expense of going to probate. What would you like to add to that question?
Well, I do think that probate gets a little bit of a bad rap because everything that you said is true. It is lengthy. It can be a bit cumbersome. It can be very cumbersome. But at the same time, probate serves a real function in society. As we've talked about, a lot of people, a good percentage of the population, does not actually prepare a will. And so something's got to happen with that stuff, right? If you have a bank account, you don't want the bank to just keep the money. If you have a house, so there's a real function that it serves. On the other hand, if there is a way to kind of shortcut that process, would I prefer that my clients shortcut the process usually? Yes. Yes, I would. I mean, there's no question about that.
Yeah. In your experience, how long is the probate process in Missouri?
Right. Well, there's some statutory minimums, and so that you have to comply with. But really, the fastest estates that I know, and they're simple and there's not a lot going on, are usually going to take 6 to 12 months. Then you have problems with some courthouses actually being kind of backlogged right now, that they have a lot of cases. So hearings might be set out right now. At the moment, of course, we also have COVID factoring in. But even if that were not an issue, it still can be, there still can be a backlog. I know St. Louis County has had a backlog for many years, although they are trying very hard to rectify that. They were before COVID. And so hopefully, those processes will be more and more streamlined. But it can definitely be lengthy. And that can be a problem if your loved ones can't access money that they would need, for example, to pay for school if you've got tuition. And then you have lenders that come in there that can charge a significant amount of interest against the expected inheritance and so forth. So anything you can do to expedite the process is great. And for your first homework, what I like to tell everybody is if you are alive, you need a medical power of attorney. And I assume everybody watching this is alive. So you need a medical power of attorney in place, which you can get free from the Missouri Bar Association. But you also want to make a list immediately of all of your assets, everything you own, and make sure that there's some arrangement of some kind to make sure that those assets can be taken care of prior to your death and after your death.
Oh, so in order to make a probate plan or an estate plan, you have to do it while you're alive?
Well, yes, planning is definitely easier when you are still alive. So as we've been talking about, you will go automatically to probate if you don't have a plan under the laws of intestacy. But when you have plans made and documents in place, then things can be distributed. And I mentioned a little scenario there in my last answer, and that was before you die. So a lot of times when we think about estate planning, we think about death, and that is obviously a very natural and logical assumption. But powers of attorney and other documents are also very useful in cases of a car accident. Unfortunately, these things happen. Dementia, confusion, comas. There can be many other instances when the individual is still alive, but for whatever reason cannot handle their affairs in that moment. Where this can become a very big issue is if you own a business, especially a business that is time sensitive, a restaurant, for example, a law firm. We're both lawyers and we have to have people there that are going to instructions, these documents are here, these documents are there, so that you can step in.
Yeah. I just wanted to remind our viewers that we are available for questions. If you'd like to type one up and hit send, we can review the question with the two of us online. We'll put it on screen too if I can figure out how to do that. So, these questions that we're answering were
I just wanted to remind our viewers that
prior to the broadcast. So let's go ahead and go on to the next question. And I think this is a good one. What is estate planning? I'm not wealthy. Why do I need to have an estate plan?
Right.
Yeah,
That's a really good.
that's a really common question, right?
Absolutely. And so I joked earlier, if you technically having a medical power of attorney is part of an estate plan, and that is available, as I've mentioned. I like, as a public service announcement, the Missouri Bar Association does have an advanced healthcare directive, a power of attorney, durable power of attorney for health affairs. So really, this is something, particularly right now in the COVID era, and in the future, that people should think about doing. I like to do it with my clients because I can review their decisions, obviously in a more personalized manner. But that form is available. But even if you don't, unless you own nothing, if you own absolutely nothing, then maybe an estate plan isn't a concern. If you have zero bank accounts, zero vehicles, zero possessions that you care about, maybe your favorite guitar or anything that you want to pass on, that might be of some monetary value or sentimental value. So if you own absolutely zero, or nothing of any sentimental or emotional or monetary value, then maybe no estate plan is not a problem. But if you own anything, I always refer back to the example of my sister. My very first car was a hand-me-down for my sister, a gray Ford Escort that was not too beat up, but was already, I think she had bought it used, but it got me to and from. It was my first car.
Not to
And
date you, but what year was the car?
oh, I don't know. I mean, it was like 5 or 6 years old, maybe 7 when she gave it to me. So I think it was like 7 years old when she gave it to me, but I owned it for 4 years and it got me through the rest of college and my very first job, my first few jobs and things like that. So those hand-me-downs can be then, a building block for the future. So as you kind of engineer your career and your plans, definitely this is something even young people should take a look at, to be honest.
Yeah, I remember the first case I had, the first case out of law school, and it was a probate case, and the will was from 1974. All of the witnesses were dead. The only person I could find to try to prove the will, because this was before what we call self-proving wills was in effect, was an attorney who recognized the signature of the former, I think it was the former assistant of the person who had drafted the will, and there were sprinkled across the country 17 or 20 different people who were expecting assets to be distributed through the will. And of course, as a brand new lawyer, I had never handled one of these, and it was a real delight to try to learn on that kind of a case. Let's put it that way.
Yes.
So that experience is one that really taught me a lot about how to handle individual clients and how to figure out probate and how to then, looking back, you look back at this experience and you say, well, how could this have been planned better, right?
Mm-hmm. Right. Well, and it's the worst time. Sometimes, I mean, you assume that anybody that you're leaving money to or assets of some kind, they probably care about you, right? Otherwise, if you don't have a relationship with them, you probably wouldn't be leaving them anything anyway. And that means that they probably care about you. Sometimes that can be negative. You maybe like you're a parent and your kid has a lot of emotions to work through, or it might be very, very positive. But either way, it's probably going to be a very difficult time in their lives to have lost you one way or the other, and to have to deal with paperwork. And maybe you're a mom and you have young kids, and maybe you're a dad and you have young kids and you've lost your wife. And so these are difficult times. Whatever the emotional response is, it's going to be somewhat difficult to get through this process.
Let's actually, that's a good segue into the next question, which is, look, my parents never talk about their estate plan with me. And I think our generation, Generation X, is probably experiencing this quite a bit right now with our parents aging and a lot of times passing away, and trying to have a frank discussion with that generation, which, for example, in my own family has been quite secretive about plans and assets and whatnot. So this is a really good question. It hits home for me personally. How do you see that?
Well, it is a common problem, and there's sometimes not a lot that you can do. I mean, there are different things that you can try. You can try, for example, if you have a parent who is kind of refusing to talk about things, all of you can get together, like the siblings, the next generation can get together and try to talk to them. Sometimes it might be that the parent always had a better relationship with this daughter or that cousin, or sometimes they might respond to a doctor saying, your kids are calling me and they need you to do this because this is important. But one of the things that I would say to anybody who's listening to this, who maybe hasn't done that or has some reservations, is that it is a real gift. It is going to be difficult for your family and friends to lose you. That's just a reality for most human beings, that we all have relationships, or many of us, most of us, I guess, have relationships where somebody somewhere cares that you've passed on. And so that's going to be a difficult time and cumbersome. Maybe they're just your neighbor and they're doing somebody a favor. They're trying to get this taken care of for you, but it's going to be cumbersome. So whether there's a strong emotional connection or not, it's a gift to say, hey, this is what I own. I am responsible for this as a property owner. Part of my responsibility when I own this item is not just to own it and enjoy it, but also to figure out what's going to happen to it when I pass on. And so I think putting it in terms of a gift to your family, if there's anything, like I said, it may not seem like it has a lot of value, but it could be a roof over your head, a roof over your grandkids' head. It could help somebody, your daughter, go back to school, or your son finish that degree that you never finished. All of these they seem like a small amount, but unless you own zero, it's worth looking into. And
Yeah.
there's also, Rick, can I go ahead and talk about non-probate transfers now?
Yeah, why not? So what we've been chatting about is probate and preparing an estate plan, with the focus being on a will and estate planning documents like powers of attorney, which we'll talk about a little bit more. I know there's a question coming up. Actually, I think it's the next question, but non-probate transfers is a really important aspect of doing the entire plan. And the whole idea with non-probate transfers is to kind of harken back to what we chatted about at the beginning, which is what is probate and how long that process takes. And that's sort of the place you want to try to avoid, if you can, by putting into effect documents while you're alive to save your family and your loved ones who survive you the headache and expense and really the process. So there's a whole set of different aspects to estate planning, and I'm glad that you brought that up. So I would say, go for it. What is non-probate transferring?
Well, it's something that, as you said, an attorney can make it a part of the plan. But what I really like to tell my friends is that there's a lot that you can do for estate planning that actually doesn't involve an attorney. Of course, this is what I do for a living. So if you want to contract and retain AJ Legal Services, please do not hesitate to do so. But there is realistically speaking, a lot of my friends don't own a ton, and so you have to weigh that expense of an attorney versus a non-attorney and figuring out how you can do it on your own. So if you do have a bank account, most people do have some kind of direct deposit for their work or other arrangement. Even if you only have $500 in there, it doesn't matter. Not a penny should be lost. My philosophy is not a penny should be lost. So make sure that those bank accounts are payable on death. The second thing is if you own a vehicle, make sure that you've gone to the Department of Revenue, retitled your car, and gotten that transferred to transfer on death. When you fill out the application for a new title, there's the owner name on the left, top left of the form, and directly to the right. In Missouri, you're allowed to designate an organization, a trust, an individual who can receive that asset on transfer on death. And that's really important because actually a lot of states, not all states allow transfer on death and payable on death for all different kinds of accounts. If you have any other kinds of accounts, any kind of investments or anything like that, anybody that holds your account, you should contact them and ask them if they, how to put it, make it payable on death. So it's the same thing, transfer on death, payable on death. Your medical power of attorney, like I said, you do not need to have an attorney. Missouri Bar Association, public service announcement, they do allow you to, they have a link there for you to fill out a power of attorney for medical. Then if you own a house, and usually with those items, you've covered most people. If you have a house, you can do a beneficiary deed. That does require an attorney, but it's not expensive. It's not a lengthy process. Usually it shouldn't be. And so it should be easy, pretty easy. As long as you have clear title to the property, a beneficiary deed shouldn't be a problem at all.
Yeah.
So those are the things you can do without an attorney.
I know I said that the next question had to do with powers of attorney, but another question came in the meantime.
Okay.
This is from Dan Duffy. Hey, Dan, thanks for watching and thank you for your question. The question is, it's hard to know where to start. What do I need to have together for a lawyer when I want to get started? That is a great question. I will start the answer if you don't mind, and then you can clean up whatever I mess up. So usually when I meet with folks and they're looking at preparing an overview of their estate plan, I like to have them bring in a lot of the documents that Alexandra just mentioned. Titles to vehicles, that would be one aspect. Bank account statements. If you own a home, I'd like to see what's called the general warranty deed, because that will give us the legal description of the home in order to be able to draft the beneficiary deeds. Will actually be one deed per house. So if you have more than one home, then and if that's a vacation home that it's in another state, then I would be telling you to bring those deeds as well. And when, the question might have to be passed to an attorney where you have the real property located in. I would also ask people to bring in account statements from any brokerage accounts. I'd like to see their beneficiary designations for any 401ks. I'd like to see their beneficiary designations for any IRAs they may have, whether it be Roth or regular. And if you don't know what those are, we can discuss those later. So really, I like to have a good look at the life insurance policy too. So if you have life insurance, any documentation showing that. So any assets that you own, I'd like to see sort of the titles to them and any beneficiaries that have already been made. What about you, Alex?
Well, I have a questionnaire that I send out to my clients, and I actually have them list all of those assets. The biggest thing is to know what you own. As we've been talking about, once you have that medical power of attorney in place, because everyone who is alive should, I do firmly believe that your attorney, your doctors should know, and somebody close to you should know what your wishes are, and that should be designated in the paperwork. So after you have that, I have a questionnaire that I send out, and my clients can fill out a list of everything they own. The other thing is, it's not just what you own, but what you owe. So for example, if you have a car, you're going to need to know if there's a lien on that car because it may transfer to another individual, to your son or daughter or niece or nephew or what have you. But there will be a lien on that car, and that's going to evaporate when you pass away. So the debt will transfer with the asset. But every kind of debt, and actually I always have to look this up no matter what client, because every kind of debt has its own peculiarities depending on what type of debt it is. So a mortgage, it can't just pass to the next person because the bank has to approve that next mortgage holder, and they might actually call in the note. So that asset might have to be sold. Anybody living in it will have to move out. If it's credit card debt, if it's student loans, all of those types of debt have different rules with how they transfer or what happens to them at the time of death. So I have a list that lets clients kind of get an overview of everything they own, and that's when we go from there. The reason I use that questionnaire right off the bat is because what Dan said, it's hard to know where to start, and a lot of times people don't have all of those documents on hand because there might be some time frames for different things, credit ratings that start getting affected if bills go unpaid and so forth. Automatic withdrawal is a big issue. So that'll come out when the person has died, but maybe there's no longer any money coming in because the employer knows of the death and is no longer depositing that, or things like that. I want to get as quick an overview as I can, and we can look for the documents and the statements later, probably quickly, but just usually the list is a little bit faster.
Yeah, that's a great idea. So let's go on to the next question. What kinds of powers of attorney are there? I like to tell my clients that I think the misconception is that there's only one kind, maybe among the public, but there are several kinds. I like to call the first one, which is called the general durable power of attorney. I call that one the financial power of attorney. Because that allows the person you name as the legal term being attorney in fact, which of course is really perplexing to a lot of people. Attorney in fact, a lot of lawyers, I think, misunderstand that term because it has the word attorney in it. The word in Spanish is a lot more, I think, descriptive, apoderado, but that's the empowered one, right? The one that you're giving the power to make and take it decisions in your name. So it's a general durable power of attorney, general being that it covers pretty much anything you could do on your own, and write checks, open accounts, close accounts, sell stocks, buy stocks, sell real estate, buy real estate. I can't think of a limit to the financial transactions that one could engage in life. And then the durable part of the term means that it continues on even if, and it continues in effect, even if you happen to be non-compos mentis, which means that you have an inability to speak or to communicate somehow. Unfortunately, some people have accidents and they end up in a persistent vegetative state. They're still alive, but they can't really do anything for or on their own behalf. They can't pay the medical bills. They can't take care of the transactions that need to be continued. They can't pay their rent. They can't pay their mortgage, or whatever the aspect of their financial life continues, even while the person is unavailable mentally and physically to be able to do that. Some people also, suffer, unfortunately, from diseases which end up being progressive and permanent, like Alzheimer's, et cetera. And when those folks end up in that type of a state, why a financial power of attorney can be a real boon to the family to be able to take care of their assets in their mental absence. The other one, would you like to make any more comment about the financial power of attorney?
Well, I mean, just in terms of powers of attorney in general, I like to explain there's like medical and asset-based for financial assets for homes. and they can be drafted quite narrowly. Like, I want to allow this individual to be able to do such and such activities with regard to this house or this bank account or this particular asset. So it can be very, very specific. You can make them for the duration just for the sale of the home. So I want them to have be able to handle this particular transaction or the purchase of a home. But after that, it expires once, at the time of closing, or whatever terms you might designate. So they can be very specific and they can be very broad. You can say, I want them to have full control of all of my assets as of now. And they can be drafted. So those are the 2 points. They can be drafted narrowly or broadly, and they can also be drafted narrowly or broadly for medical decisions. So I want them, I'm expecting to have a surgery, and the doctors are telling me that I am going to be out of commission for a full week because of the medications and all of that. But I also happen to have a very important, there's some scenarios and some decisions that need to be made, either medically or with some other transaction that I'm in the middle of. So you can draft those really carefully to meet the tailored needs of the situation.
Yeah, and so you mentioned the medical power of attorney, and I think Missouri's bar, the Missouri bar is, and I think you mentioned this earlier, is yeah. So the Missouri bar has the medical power of attorney available free of charge on the website, mobar.org, mobar.org. And to confuse things a little bit, in Missouri, we call it a living will. So it's not to be confused with a last will and testament. We also have another term for it called a medical advance directive. So it's the power of attorney, the medical power of attorney has an advance directive contained within it. And the living will part is a name that I'm not sure where it came from, but maybe it was made up by lawyers to confuse people so that they had to seek legal advice. I'm not sure if that's true, but that certainly occurs to me. But a living will is the same thing, same document that Alexandra and I are talking about, which is also known as an advance directive, which is also known as a medical power of attorney. And those are the in the Missouri one, and I like the Missouri one because it allows the individual to make the decision in advance about medical treatment and procedures that could at some point happen to them, or at some point their loved ones may be in a place and position to be able to, or to be forced to take decisions because you're unable to take decisions. And what I always explain to my clients about the medical power of attorney or the living will or the advance directive is that it's a very loving document. It's a document that you prepare in advance so that you remove the burden of making those really difficult medical decisions from the person who has to implement the decision. So because when they look at the document that you've drafted, the power of attorney will say, I want to have this withheld, or I want to have this done. And there's an entire list of different medical procedures contained in the Missouri form. And so if your son or daughter, for example, has to be placed in the position of being in a hospital and wondering what you would do, why, there it is in black and white. I've already decided what I want. All you have to do is tell the doctors, follow the things that I already told you in advance. That's why they call it an advance directive. And I like that document. It's a document that I wish we had had perhaps when my grandmother was really, really sick about 25 years ago. We didn't have one in place, but it would have taken the burden off of my mother to make the decision whether to maintain artificial ventilation. Ultimately, she recovered without having to have that decision be made, but it would have been nice to know what my grandmother would have liked in advance. So I think it's a loving document.
Really I really like how you're calling it loving document. It kind of ties into what I was saying, calling it earlier, which is a gift. And this
Yeah.
is really, it really is a gift. You make things easier. Nobody wants to be standing in the hallway of a hospital trying to figure out what mom would have wanted. Would she want the surgery? Would she not? And so it's important to communicate those in these documents. It's also important because no document is really going to probably be that comprehensive. Most documents kind of give a power to somebody to make a decision, but of course, medical treatment that exists at the time that I mean, if we were, for example, trying to make a medical directive right now for COVID, literally tomorrow there could be a completely new procedure that's not contained in the document. So generally powers of attorney of this kind are more general, are more broad, and they can make that decision. I do want to clarify a little bit. I mean, there is a statutory difference between the living will document and the power of attorney. Those do come under different documents, like or different statutes rather. So they are kind of different, but there is a relationship and between those that they do cover similar areas in the sense that they're both medical. But a medical power of attorney is not actually the exact same thing as a living will. In a living will, you'll be talking about, it's usually very short, and it specifies whether you or not you want like what level of intervention you want. Do you want them to try to resuscitate you, or do you want a do not resuscitate order in place? And so are they going to take extreme life-saving measures or not? So that's kind of the level you're gradating, and that helps your family. As Rick says, it's a very loving gift because you don't want them to. You were talking about your grandmother, and in my mom's case, who has Alzheimer's, my sisters and I have had to have conversations where, you know, if this happens, what are we going to do? Are we going to do this? Are we going to do that? She has a DNR. The other thing about a do not resuscitate that's important to know in terms of the wishes and the documentation is once you call 911 and EMTs arrive, they may have their instructions may be, depending on the scenario, depending on what documentation you can provide right then and so forth, they may say, we've got to save this person. We've got to take, now that we're here, we have to do everything. So in some kind of chronic situations where you have cancer, where you have hospice, Alzheimer's, and other situations, the question may be, do we even call 911? Do we get EMTs here or not? So those are very difficult conversations to have sometimes among family members, but it is very important, if you can at all, have them safely to go ahead and do that beforehand and know what's going on.
And that's an excellent segue to the next question, which is, do I need to create a medical directive?
Yes, I think we've been saying, both Rick and I are emphasizing, at least I am. I think if you're alive, you need to have some kind of medical decision making in place.
Yeah. I think, you know, some people believe that, oh, I want everything done to be able to save me, do everything you can. And some people say, nah, just, you know, pull the plug. So the point of the medical directive is to be able to tell people which side of the fence you kind of, you know, fall on in advance, so that they know, oh, you know, Granny wanted to have the plug pulled, or no, she thought that you know, we should do everything we can to save her, and so that's what we're going to do. But do you need to create a medical directive? I say it's very loving. It's a very loving thing to do for the people around you, the people you love, so that they don't have to guess as to what your intentions are or would have been if you're unable to make those decisions on your own.
And they take care of you too, right? I mean, you might, you know, you might want them to make a decision. And I'm sorry, Rick, are you still there? Because I had a little thing
Yeah.
going. Yeah.
Yeah.
So, I mean, it is incredibly loving. That's great language. I really like it. But I'm probably going to steal it now. I'm going to be like, oh, it's such a loving thing to do. It plugs right in with my gift language. But it also takes care of you, right? Like if you want measures to be taken that maybe your sister doesn't, or your wife doesn't, or your husband doesn't, but you're like, so your doctor, there are times when your doctor might look at that file and say, I have something in paper that tells me I need to do X, Y, or Z. And so even if you're telling me something different, we either need to clarify that, or I'm going to go ahead and err on the side of caution and use life-saving measures that may be more than the family member might have preferred, but that the actual patient put into writing and wants the person to do. So if you want to be saved, this is all about having some extra control over situations where a lot of control might have otherwise been removed, where you can no longer make that decision, where you're in a coma, etc.
So, Alex, we have about 15 minutes left, and we have 2 questions still pending. The next one is, when should I make updates to my estate plan? That is a great question. I like to tell people generally that if no major life event occurs, for example, there's no death, there's no marriage, there's no births that occur, I think you should pull it out a minimum of once every 5 years. That's sort of my guideline. If those events do take place, divorce, marriage, births, deaths, those types of major life events, then a review of your estate plan should sort of coincide with the timing of those events. I don't know if you have other suggestions to folks.
No, I think that about follows. I mean, if there is a life event, anytime somebody in your plan dies, anytime you get married and you adopt a child, anything like that, that those life events have to be addressed in your estate plan. And there are some very painful cases of people who did get divorced and then got involved with another family, and children from the second family not getting anything, even if their relationships were sometimes closer than your first families, or a wife or an ex-wife, or et cetera. All of those arrangements. I'd like to say 3 to 5 years. It doesn't hurt to start thinking about it. The reason I started doing that is actually because of my own life experience. Because I said 5 years, and then it took my husband and me a couple of years to have time to have all the conversations that you have to have and think about things. So if you start,
there's like a point of inertia that you have to sort of get over, right?
Well, for sure, inertia, but even if you have it on your to-do list, I have people that I've worked with, and if you've got young kids, having the time and the energy to have a serious 1 to 2 hour conversation about, I am never going to let your sister have my children. Some of those conversations can be kind of difficult, right? And so having the time and the energy to do it can take a while. Can literally, like, you can schedule it and you can try, but then something else comes up. So I like to say 3 to just kind of get started, so that hopefully by the time 5 years roll around, this is pretty much what we want to stick with, or no, we want to make changes. Obviously, if you're done at 3 and you want to get those changed, you've made a decision, then do it at 3. You don't have to wait till 5. But I like people to start thinking about it and make sure that everybody's still alive, that nobody's gotten married. My kids have guardians in place, and we've told them both, if you get married to somebody we don't like, that might change, right? Because then my kid's guardian might be married to somebody who, for some reason, I have a concern about. So yeah, just keep track of it. It's just something to keep track of.
Yeah.
And a lot of us don't, but it is really important.
And I think in the experience of, young couples who are recently married, and maybe they've started a family and they have young children, a lot of the sort of barriers that come up to putting an estate plan into place is deciding who among their family members would be the right person to take care of their children in the event of simultaneous death. And so who do you name as their guardians and who do you name as their conservators? The people who you want to raise your kids, the people who you want to make medical decisions on behalf of your children, educational decisions, instruction in religion, if that's important to the family. And a lot of times the husband and the wife have a sort of a difficult time coming to a consensus as to who might be that person or persons. And that can really sort of stop the whole process in its tracks. And I know that that's probably not a unique situation.
Yeah. No, it's not. In fact, I think it's actually malpractice or almost malpractice. I don't know of any actual cases who have been litigated in this regard, but it's almost malpractice to not anticipate family disputes or disagreements of some kind, especially when you have, I mean, if you own very little and it's your sister, your neighbor, your brothers who's going to just kind of sell anything you've got and let let the nieces and nephews come over and see if they want your vases or your paintings or whatever, that's not a big deal. But when you have a long-term situation such as raising a child, the odds that no one in the family will disagree with you ever with any decision that you're making are just literally non-existent, right? So grandma's going to have an idea. Grandma had ideas when you were alive, right? So she's way going to have ideas. Or, Uncle Joey, who always took care of the kids, but maybe doesn't live here, or, you might decide on a guardian for a number of reasons. But the odds of family always coming together is just impossible. And if you have a chronic situation with a minor who is several years away from not being a minor anymore, from emancipation, or you have many years of a chronic disease, I've mentioned Alzheimer's, if you have somebody where, there's going to be disagreement. So the question is, how do you handle the disagreement? And if you put mechanisms in place into those carefully crafted documents that people can, maybe they're going to be out of the country for a year. They're going to go study, like your guardian or your power of attorney. Well, make sure that there's something in your documents. I like to put something in that says I can notify my backups, basically the people who are the successor trustee or the successor power of attorney, the successors, that I'm going to be out of town and they need to handle these affairs for the year that I'm on sabbatical in Europe or whatever the case may be. So have those documents, those mechanisms in place to deal with a long-term situation where life goes in a lot of different directions. If there's any disagreement, this is who I would like. I'd like you to consult with my attorney. My estate planning attorney can often mediate. Of course, there's professional mediators, there are professional therapists, family therapists. So make sure that your documents allow for the payment. You can use my money to pay for anybody that you have to hire in order to determine what my best care is, what the best way to go forward is. So I really think those are so common, it's almost malpractice not to anticipate them.
I don't know how you've done this, but you've anticipated the next question, and this is the final question, because you started talking about conflict. And here's the final question. I'm worried my family will contest my will. It's not really a question; it's a statement, right? So,
right.
What happens in that case? How do you first of all, you anticipate it, but then how do you sort of deal with it? Talking through it with your estate planning attorney and trying to figure out how to address those types of issues in the estate planning documents.
Well, Rick, I don't know what you do, with your cases. For my part, it goes back to that question that you had earlier about talking to your family members. So one of the best things that you can do in most cases, and it may not be universal, but in most, because it does obviously depend a little bit on family dynamics, but one of the best things that you can do is talk to your family about what your wishes are and what arrangements you've made to make sure that those wishes are adhered to. To the best of, some things you're just going to have to let go, right? If you're comatose for 3 years, there's going to be decisions that are made that you're probably not going to agree with once you come to. Or if you pass away, there may be decisions made that you would not have agreed with exactly. So some things you are going to have to let go, but the bigger desires, the bigger wishes, you want to make sure that those things are talked to. I'm just going to, don't want to disclose information. So for our part, my husband and I made arrangements for our kids, and we notified first off, we asked the guardians, of course, we asked the guardians if they would be guardians.
You mean people will name guardians without asking them in advance?
Yes, that has happened. People will name powers of attorney. So try not to name anybody that you have not received, whose consent you have not received. So ask them first.
Yeah.
And then tell everybody. Tell for various reasons, we actually stepped outside of our immediate kin for the first 2 levels of guardianship. I'm an estate planning attorney, so I have 5 levels. Yes, for my guardians, for my kids. Well, because we're all always at the same barbecues. We're all always at the same events and the school plays and stuff. And what if, a tornado or lightning or fire or something knocks out the first 3 levels? So I'm cautious. And we have multiple levels. But we then told everybody. We reiterated. We didn't just tell them when we first did it years ago. We reiterate it periodically, like, this is who, this is who's going to get the kids. This is who's get the kids. Who's going to get the kids. And so that talking to people and letting people know is a big deterrent for them later to go to court needlessly, because they'll know, hey, I can go to court, but Alex and Brian already told me what is going to happen. And so I can waste my money, or I can just be mad at everybody, but not waste my money. It's the choice of litigating or not. The other thing is, and there's different schools of thought on this. I'm interested, Rick, in hearing your thoughts. These days, I just put an interorum clause in all of my documents. I say, if you contest it, you lose. You lose out on, if there's no reason for you to contest. Even now, people are sometimes finding ways to get around it. But the last thing that I want is for people, my loved ones, to fight amongst each other. And fighting and grieving, words can be exchanged. But once you go to court, sometimes, those types of hearings and proceedings can rip families apart and create wounds that will never heal, that will not heal. So deterrence is a big part of my planning and my thinking, is just make sure they know what the carrot and the stick, they know what they're going to get, what they're not going to get, who's getting the kids, who's not. And also, if they don't comply, if they choose to contest this, then they're not going to get anything. Then they lose all, standing to receive anything as a beneficiary under my estate plan.
Yeah. Well, I think that's
and everything. I do.
Say again?
Do you put interorums in all your documents? I do.
Typically, yeah. But it's sort of, something to bring to the attention of the client. If that's the language that they want to put in, they need to be known to be made aware that it's available. And I think most people would agree with you. I can't thank you enough for the time, Alexandra, and I can't thank the viewers. Lamentably, our time is up. We have about 30 seconds. So I think I would just end by saying, look, if you're interested in doing an estate plan, you should probably do it before you die. And I would do it in consultation with a qualified estate planning attorney. So,
except for what you can do without an attorney. I like to tell you, except for what you can do without an attorney. There's lots that you can do without. And I prefer to just let people know that, because it's really important.
Yep. All good things. So thank you very much. For those of you who speak Spanish, we will be continuing this in Spanish in about 1 or 2 minutes. So thank you very much.
Momentarily.
Bye, everybody.
Bye.